Yes, Mr. Smith, what do you want to say?
I would like to fire Lauren Brown if I need to get representation. Me and my mom, we got plenty of money. We can hire somebody to represent me. I will no longer want a public defender like him.
Court does call the case of People versus Jerel.
Well, Jerel. Roll on behalf of Mr. Daryl Jerel. Mr. Jerel, please state your name for the court, please.
Good morning, Judge Simpson, Daryl Jerel.
Welcome back.
Right, thank you.
And Your Honor, please.
So that we're clear, has Mr. Jerel taken care of his other warrants?
Have you taken care of your
I have. I've addressed all
You
of
took
them.
care of the, okay. I just want to make sure because
Yes.
we don't need another thing like he did.
Yeah,
last
thank
time.
you. Thank
It's
you.
on top of
All right.
everything.
Trying to avoid that subject.
Yeah, well, I am too, but you started it.
The confrontations I've had over that.
Well, you started. I didn't know why. I was trying to be
Very
nice to him.
humbling experience.
What did you say?
Very humbling experience.
Yes, it was, but we got past that. But I know that at some point you didn't appear on those, and there were warrants, and I wanted to make sure they're clear. They're clear
Yeah.
for you. Okay,
So,
good.
Judge, it sounds like me being appointed yesterday, I missed some excitement on this one. I'm also missing some.
Oh, there's a video.
Oh. So I'm sure it's viral.
That's okay. He can get it to you. No,
Yeah, that's some homework for you.
he's gonna
I
just
don't
shake
know
his head.
nothing.
That's exactly. Judge, we're just asking for an adjournment at this point. I was appointed yesterday, so he
Got
discovered it.
it. Okay. So adjourn the probable cause conference, but Mr. You're doing okay.
I'm on the right track now, Your Honor.
All right.
Thank you.
Probable cause conference, November 13th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
I'll meet you on the hallway.
Court calls case, People versus Trina Gayton.
Trevor Mayville for the people.
Good morning, Your Honor. Mary Rubio on behalf of Ms. Gayton. I'm standing in for David Burgess with his permission. Is that correct, ma'am?
Yes, ma'am.
Okay, please state your name.
Treat a guy. Good morning, Mr. Simpson.
Good morning. All right, you're asking for an adjournment?
Yes, Your Honor, we were just recently retained. I also would like to address bond when it's appropriate.
Probable cause conference will be adjourned to November 6th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, it is my understanding that Ms. Gayton unfortunately failed to report to community corrections, and that's what has her in the situation she is in today. But I wanted to indicate a couple things. She indicates that she did call twice early on in October, and at that time, on 2 different days, she was told they did not have the paperwork and that she needed to call back. Ms. Gayton openly admitted she did not try to make any excuses. She said to me that she simply forgot. Ms. Gayton, unfortunately, has been diagnosed with lung cancer. She has received 1 round of radiation treatment. They have found another nodule. She needs to get more treatment. She's 63 years old. She also suffers from blood clots in one of her legs. I'm asking that the court would consider reinstating her bond. She understands the importance of complying with all terms of her bond, and she knows that she needs to follow up with community corrections.
Any response?
Your Honor, I want to note that my office did intend to extend a misdemeanor offer in this case. When looking at the ex-jail file, it looks like she has a couple of different holds, one on a case that was pled to RO attempted, as well as a minor misdemeanor hold out of Canton. Nothing else.
I'll grant the defendant's motion. Her bond will be modified. I'll reinstate the previous bond as set. Defendant needs to report over to community corrections. We'll need to prepare a new order for testing. You understand that, ma'am?
Yes, sir.
Thank you.
Thank you, Your Honor.
Court calls case, People versus Alicia Allen.
That's thoughts for people.
Worship Feaster, Assistant Public Defender, on behalf of Miss Alicia Allen, who's standing to my right at the podium. Please state your name for the record.
Alicia Allen.
Thank you.
Thank you, Judge. We are requesting an adjournment on this matter for further negotiation, and Ms. Allen would like me to address bond, please.
I'm sorry,
And Ms. Allen would like me to address bond.
gonna do it herself?
I think she wants
She
me to.
doesn't need you.
No, she doesn't really need it.
Okay, okay, but, all
I-
right. What I will do, I'll adjourn this matter out to November sixth, 2025, 9 a.m. Yes, as to bond.
Thank you, Judge. I believe Ms. Allen currently has a $35,000 bond. She is requesting of the court that the court consider a personal bond on this matter. She indicates that she is in or was in outpatient treatment prior to being incarcerated. She does hope to get this matter resolved. In the alternative, I am going to be requesting a release to treatment if the court is not inclined to grant her PR bond.
Response?
Your Honor, this is an order July 3rd. Her priors are from 2019 and 2024. At the time that she was pulled over by the police, she had previously crashed into at least one vehicle while traveling between 50 and 100 miles per hour on eastbound I-94 from Jackson County, coming into Washtenaw County. A 13-year-old child was also in the vehicle with her while she was operating at a .118. There is an RNO causing injury attached to this as well as another RNO. I do not believe any change to bond is appropriate. I would even be concerned with a release to treatment given the allegations here and the lack of compliance with lawful orders. I would ask that the court continue the bond as currently set and we can revisit a release to treatment at a later time. But I'm very concerned about her being out of custody in any way, shape, or form in this.
Anything additional, Mr.?
No, Judge.
Given all of that, motion for bond reduction is denied. Bond will continue.
Thank you, Judge.
Court calls the cases of the people versus Mohamad Murphy.
That's thoughts to the people.
State your name for the record, sir.
Mohamad Murphy.
Thank you. What are we doing? Apparently we're having a conversation.
Your Honor, we would like to set this matter for preliminary examination, and we'd also like to address bond.
Oh. This apparently doesn't carry over there. Mr. Kilowatt, I think one of these cases are yours.
Oh, yeah, that's true.
Sorry. Mr. Mohamad Murphy?
Yes.
Yeah, I know that's you, but
Oh,
on case 1701, you were,
I'm not aware of it. If you say,
well, that's apparent. I'm informing you, I signed the order that the PD's withdrawn on that case, and it's you.
you know what, it's my lucky day. Good morning.
how you doing?
Do you mind if I ask for an adjournment so I can talk with you at the jail?
How long that's gonna be?
Well, we'll get it as quickly as possible. Judge,
No, I would rather handle this today
well,
because he said that it's been withdrawn.
okay, hold on one second.
I don't-
Nothing's, all this,
I just want to go home.
Judge, I wonder if we could pass this. I can go see him in the lockup.
Please. Okay.
You being the considerate judge you are.
Thank you.
Do you have any objection to that, Ms. Akinruli? Pass?
Absolutely not, Your Honor.
All right, thank you. Okay, I'm gonna pass your case. They'll come back and talk to you.
Okay.
We'll get it all sorted out.
Thank
You're welcome.
More than one case? What do I?
Let's call the case People versus Mohamad Murphy.
That's thoughts for the people.
Seriously. I need Kilowald and I need Akinruli.
Oh.
I'm sorry.
I'm sorry, I was trying.
Assistant Public Defender Tanaji K. Jerel, Your Honor, on behalf of Mr. Mohamad
Morning, Rob Chico on behalf of Mr. Murphy.
Murphy.
Murphy, would you state your name for the record?
Mohamad Murphy.
Judge, we discussed this matter with Mr. Murphy. It's our understanding he has holds in other counties. We're asking to set these matters for a preliminary exam.
That is correct, Your Honor. Mr. Murphy would also like for us to address bond, Judge.
So you want both these matters set for preliminary exam?
Right.
Well, you'll get the discovery, so discovery is not, but you'll get it.
It is not complete, Your Honor. I will try and get over to Mr. Kilowald as soon as we can, but I haven't been able to get him everything just yet, of course, so. I still have the public defender on my file for the other case.
We'll get it, Judge.
All right, but if a discovery issue is not going to be the basis for an adjournment, you understand that?
Judge, you can count on me. I'll handle it.
Well, all right. On your case, Ms. Eckensley, you have discovery.
We do, Your Honor.
All right. People have their witnesses available the 4th.
We'll try for that date.
Preliminary examination in person, November 4th, 2025, 9 a.m. That's before Judge Fresh Hour on both cases. Bond continue.
Judge, our client wanted us to address bond.
Oh, go ahead.
Your Honor, he is indicating that he would like for the court to offer him a PR bond. We have explained to him that he does have a few holds out of county. The ex-jail system doesn't tell us or indicate to us what those counties intend to do, if they want to advise and release, or if they would like for us to hold them, hold Mr. Murphy. However, Your Honor, he's asking that the court consider giving him a PR bond. He said he does have family who lives here locally, who he will be living with. He wants us to report or remind the court that the nature of these offenses are not very, very serious in nature, and that they're not violent offenses.
Well, they are.
I
mean, there's an assault and battery and resisting and obstructing a police officer.
and
Go ahead.
yeah,
I'm sorry.
so Your Honor, he wants us to consider, he wants the court to consider a PR bond.
Judge, I'd also say he's working with community mental health. He promises to keep working with them, and he will appear for all future.
I don't need a response. In looking at the file and looking at it, and the fact that he has other holds in other counties, at this time, the court is going to decline to change the defendant's bond. Defendant's bond for motion for bond reduction is denied.
Judge, are the bond in these matters only $100 each? That's what my client told me.
On the Ms. Akinruli's case, it's a 1,000 cash surety. Might be 10% on that, the way they had the form, but the other file, it is set at a 1,000 10%. On your case, it's a 1,000. Thank you. This case of the people versus Theophilus Smith. Two cases.
I just felt this with people.
Very important, I'm married.
Theophilus Smith?
Yes,
I've got you, Mr. Smith. I'm waiting on your attorney. Whose case is
yeah,
this?
who's the attorney?
Mr. Brown's case, Your Honor.
Yeah, I would like to fire my attorney immediately. I like to
Of
fire
course
my
you would.
attorney, fire all representation.
All right, we'll get to that in a minute. Maybe he knows already, which is why he's in here.
Sorry about that. Okay. Norm Brown, Deputy Chief Public Defender, being on behalf of Mr. Smith.
So that you're aware you weren't in the courtroom, Mr. Smith did identify himself, so I'm not going to ask him to do that again. And he indicates that he wants to fire all his representation.
I understand, Your Honor. Has the court received an updated competency report?
October 22nd.
Yeah, I speak on that because I'm representing myself.
the report, the last report I have is from July, but it was
No, the only
it's
report, the only
marked that
copy
we
I took,
received
Judge
it
Simpson, the only
on
copy I took was
October
on February
22nd, but
22nd.
I don't know
February
okay,
27th.
Mr. Smith, we both can't talk. Okay, I'll hear you, but we both can't talk right now. All right.
Your Honor, we have,
I don't know that, so to finish that thought, I don't know that this is an updated report because it's dated July.
Right.
Maybe you have 2-week adjournment so we can try to figure out what's going on.
Weeks?
so I will say,
No one more? No, go ahead.
I will say this for the record. Your Honor, I believe the last report has indicated that Mr. Smith has not yet gained competency. So I'd ask the court to not fire me from his representation. To not fire me from.
No, I'm not. Yeah.
Thank you.
You already knew what my decision on that was going to be. What I'm going to do, Mr. Smith, is I'm adjourning your competency hearing. We need to get more information and then I can act on whatever you may want me to act on. But yes, Mr. Smith, what do you want to say?
I would like to fire Lauren Brown if I need to get representation. Me and my mom, we got plenty of money. We can hire somebody to represent me. I will no longer want a public defender like him. I do not want him. He haven't been to see me. He don't know none of my angles. He don't know anything. And first of all, I do not need a competency exam for a $1 prohibited fire act case.
Well,
the case is arson. It's only a case that I burned the box. It was only a $1 box that got prohibited. It was a prohibited fire act. The smallest.
okay,
I do not
so
need a competency exam for
Mr.
that.
Smith?
okay, so Mr. Smith, I can't do anything till I get that report.
Well, can I speak
Okay.
on bond then?
So
Because I mean, I think it's ridiculous the way I'm being.
Mr. Smith, since I can't do anything, I'm not going to do anything. I understand what you're requesting. I get all of that, but I need an updated report to try to figure all of that out.
But the thing
So,
about it is,
I
never
heard
wanted
everything.
a competency exam.
I know you don't.
These lawyers
but-
are doing what they want to do.
Okay.
Nobody's communicating with me, and they're doing what they want to do. I wanted to speak on bond. Ain't nobody talk about when I'm getting out of this place because I'm being.
Well, you're not helping yourself with regard to that argument. Yeah, well, that kind of close that. So I'll adjourn this to November 13th. Why not? 2025, 9 a.m. It'll be a good week. Bond at this point will continue. Thank you. Thank you, Mr. Smith. We'll see you in a couple weeks.
Thank you, Your Honor.
I think, counsel, did I not have from you a motion to withdraw?
Your Honor.
Pardon?
Yeah.
Okay. I also have, and I don't know whether or not you were served with them because I'm not clear what entirely what Ms. Tope is doing. But did you receive from Ms. Tope a motion to remove and expunge the court's order?
Got an email copy of it that I'm aware of, yes.
Okay, so you,
I don't know the result of it though.
well, first of all, I can tell you part of the result of it is that she marked it an emergency. I did not deem it an emergency. So I set it for hearing today along with the other motions. Okay, that was the resolution. The reason did you folks receive a copy of that?
Not sure what you're referring to. I don't know anything about it.
Donna Tope's motion to remove and expunge the court's order for contempt. Okay.
I don't know. I didn't think I was.
Not received. You got an email copy. All right. So then we received, and I guess I'll deal with that one first, if you don't mind. We received then a communication from Ms. Tope that she was unavailable for her own motion today. So that motion, Donna Tove's motion will be adjourned. And I'm not changing anything. The bench warrant is still outstanding. So my next date,
March or April 14th.
14th.
Yeah.
Okay, I'm a little busy that day. March 17th, 2026, 9 a.m. So that I'll adjourn the Donna Tove's motions. Council, I'll leave it to you, given your motion to withdraw, as to whether or not you want me to finish ruling on the other motions or hear your motion to withdraw.
What, it's my understanding, the last hearing, you ruled or granted liability or the motion to stop the motion, and we're here today for a hearing on damages, which I suspect we're prepared to move forward with that might result in the conclusion of this matter, which might make my motion to withdraw moot to a certain extent, and also make the defendants, we're calling it the second omnibus motion, might make
Pardon?
moot as well.
Oh, yes. All right. Folks, what do you have to say to me on the issue of damages?
So, the issue on damages, okay, so the thing he was referring to as a second omnibus motion. I just was preparing that because I was under the understanding today was the final day. You already ruled on the eviction. You were going to rule on when and the damages. Okay, so since then, there were new things that happened, such as foreclosure being posted. I've lost a lot of orders and I'm out of business. So regarding damages.
You're out of business?
Yes, and I do not have enough orders to pay my lease starting April. Most of the boarders are leaving at the end of March. They saw the posting on the door. Horse owners are like horses. They're flight animals. They're herd animals, and they're all leaving, and I'm going out of business. And so I fear, because of the posting of his foreclosure on the facility, that he is foreclosing and possibly going into bankruptcy. And so what I'm asking for damages is that it be to come out of the court's account. And that, so that my understanding is damages is up to you. And I have no recourse to get any of my money. I'm out of business. I'm not going to have the money for April's lease because of the eviction.
Let me just stop you there a moment, okay? Because you know about the foreclosure?
Yes.
Council and it's a bank foreclosure?
It wasn't a bank foreclosure, but it was the lender.
Wow. Okay. The lender. Have they leaned anything in regard to that?
I'm not aware of a lien. There was a foreclosure sale on the 4th, which the lender purchased the property out of foreclosure. So the redemption period is obviously still ongoing, but.
Oh dear. Okay. And so when we had received, and I don't know if you were aware of it, Council, I think it may have come in maybe in response to your motion to withdraw, communication from your client that it was going into foreclosure, but it actually has gone through that process, and then there.
Yeah, and so I just want to make sure that we're clear. So there's the foreclosure sale on the property at issue on the 4th. My client's personal house is also subject to another upcoming foreclosure sale.
That's a different one.
Those are different.
Got it. Okay, and so you have to remind me, how long is that redemption? That's not a 6-month redemption, is it? Gonna be
I believe it's 3, but
3. Yeah, that's what I was thinking. Go ahead, you were.
I filed this motion so that you would have all the information in front of you so that you could make a final decision on damages. Or whatever it's called. He asked me to be, he evicted me. He asked me to leave. I'm prepared to leave. I've found a place for my horses. Most of my boarders have already given me notice. And because of the foreclosure and the eviction, the fences that have always been falling down are falling down worse. I can't keep the horses safe, but I don't have the wherewithal or the resources to fix them. And I can't go on. And I'm prepared to, if you would be willing to prorate into the court's account 10 days in April, I would be prepared to leave in 30 days from now. And
What did you mean by that, prorate into?
Well, so I usually pay at the beginning of the month for the whole month. I won't have the money to do that because majority of boarders are leaving.
I guess, okay.
Yeah.
What you're saying. All right. This has got to be a disaster in the making, I think. When let me do this. While not holding him to it, counsel, is your client seeking to redeem the property or?
I believe in the best case scenario, yes.
Gotcha. Okay. You guys are going to have to, so let's say he doesn't, and then there's a new owner of the premises, you're probably going to have to leave in any event. So when can you guys leave the property?
I would love to leave April 10th, but I can leave at the end of March, if you're not able to give me a prorated lease payment for the 10 days of April.
What do you have? A total in escrow?
20,620.
Say again.
20,625.
I'm sorry, Your Honor, you said that's what's in the court's escrow?
Yeah, I was asking. It was 2625.
20,625.
And you folks have already paid the March payment.
Quick question. The March payment, are we saying that was paid into the court's escrow?
Yes, they said they paid that.
Last one being February 5th.
So you don't have a March?
I do one dated March.
I didn't bring the receipt with me, but I did pay it March. I paid it. Did I pay it at the end of February because it was before we left on vacation? I think I paid it the last Friday of March because we left on vacation Sunday. So I want to make sure it was in before we left.
Did you pay?
I'm sorry, the last Friday of February. We paid it cash the last Friday of February.
Did you pay it here?
Or in Tulane?
Well,
it really wouldn't matter. Do you know what court you went to pay it?
no.
I do see it because you paid it here. It's not on the ROA. So
And then it's got to be transferred over. So 5,500 additional.
So $26,125.
How long was your lease?
It was supposed to be 7 years.
You have how many horses are you moving?
I'm sorry, how many am I moving?
How many? Yeah.
Just my personal horses. Everybody else,
Okay, that doesn't answer my question. You're getting like that other guy.
I own.
3. So come the 10th as you're anticipating, you're moving 3 horses, or are you moving 3 horses and then some others that you're in care of? I guess I'm trying to.
There's 3 other horses that are absentee owners, and I haven't reached out to them yet because I was waiting to see when my leave date was. I'm going to reach out to them and see if they want me to take them because I'm just going to a friend of the family's and they're just pasture horses. But no, I'm not continuing this business. Does that make sense?
No, well, yeah, there's a lot more information I needed, but I'm just trying to figure out if I were to give you till the 10th, you're moving at least 3 horses, but up to 6
Yes.
total horses.
Me personally, yes.
Right. Okay. And as you're moving them, I know approximately what it's going to cost to move horses, but I don't know how far you're going. What's your cost in moving those horses? Just give me your 3.
$100. I mean, if that. It's my trailer, my truck,
Okay.
my gas.
So you don't got.
Correct.
All right. Okay, before I make a final determination of the damages on this, any other additional argument you want to make regarding that?
Yeah, couple points.
Yes, sir.
Just so that when I'm on the same page and we're all on the same page. So I have back in June of 2025 was the last rent payment, and it was a partial payment that was the water heater. Subsequent to that, until this court directed Ms. Tope and defendants to submit money to the court's escrow, I believe there was the subject of a number of hearings prior to this that Ms. Tope had an escrow account personally where she was maintaining monies of some sort for June until, because I have, for example, as of March, a total outstanding rent due of $48,691.04. $26,125 of that is accounted for in the court's escrow account. The other $22,000 and some change might be in Ms. Tope's escrow account, which started this whole issue. And so
can I just stop you there? That you understand what counsel's indicating about the difference in the money?
One correction, I did pay Fixing Houses LLC directly in July. I paid them the full amount in July.
Okay, but Right, but we still have a discrepancy amount. So I'm going to ask you folks a question, okay? Did you give that money of these missing, I'll call them missing, but the payments that did not get to the plaintiff, did you give those monies to Miss Toe?
They were dispersed. That's the money that was dispersed for repairs.
Okay, but right,
Anybody who
but what I said, yeah, okay.
Yes.
Hold it. You did not, okay, listen closely to my question because it's really important. You did not disperse those funds for repairs, right? You gave that money to Miss Tope, who was holding it in whatever to then disperse for repairs or pay for it.
Yes.
Okay, because hold on, understand, there's a reason why I'm asking this, and there's a big difference. Okay, because what counsel's indicating, I believe is correct, but I just want to make sure on the record that we have it. The $5,500 that you would pay each month that you would have normally paid to the landlord in this case, there were some months you paid those funds to Miss Toe to hold and or to use for repairs and other things.
I believe that was August, September, October, July. I paid.
Hang on a second. Hang on. Just slow down. I didn't ask what months. I want to make sure that factually what we're, because Ms. Tope's not here, factually that's correct. Because that's what I understand also, but I don't know that you've ever been asked that directly.
Yes.
Okay. So there's then this escrow, and you're saying that that was 3 months, if I'm hearing you correctly, that you would have given the monies to Miss Toe.
I would have to look at the accounting records, but I believe it was August, September, October. I believe it was 3 months.
August, September.
November, right?
Our first payment was, I think that's right.
See, just so that we're on the same page, I believe the November payment was paid to my client and it was a partial payment.
It was a partial payment in November. Right. So,
But I also paid
but you paid the difference of the 55 to the court. No, you paid the 55, but part of it was the check he received.
It was a double payment that month because of an error by Ms. Tope. So he received the check from Ms. Tope. We also made the payment. So that month had extra.
I believe in November, we paid the full $5,500 to the court. Is that correct? So was it 41?
You pull me
25 is what we.
You received
41.25.
Yes. He got 3,600
on top of that.
So it was more than the 5,500.
It was $3,508.96.
I remember that being paid, that because that was a check Ms. Tope sent to him, right?
I don't know how we got it, but my records show that we got it.
Right, that you got it. And the question was whether or not you could pay or whether or not you could use it. And because there was then the full amount, I said, you guys keep that money. The difference I thought was being paid into the court.
And so I accounted for that in my previously stated number. So I'm just trying to bridge the gap between what the court has and what hopefully should be in Ms. Tope's escrow, personal escrow account.
Okay. And that number you gave me was 48,691.40.
Not 44, so 4 cents.
4 cents.
4 cents.
In November, though, it was overpayment. Because we paid
Well-
25 and 3,500.
Well, I don't know. We can really look at it as an over.
Okay.
I mean, because ultimately there's going to be a certain amount that should have been paid. The real question is where it went. I guess is that.
I think that's what you were gonna ask for.
Yeah, that's what I was. Okay, and I know why that happened. What I did is I think I prorated. So I allowed him to keep the check. It really wasn't a double payment. So here's what I recall doing is the money that was sent to the plaintiff, I allowed him to keep that upon the court's original. And then when ordering escrow, I ordered it pursuant to the court rules so that it was ordered prorated for the period in time. And I went back, although you paid it on the 18th, it was back around the beginning. When was our first? You didn't run the whole thing, but whatever our first date in November was, I prorated it from a date in November, which is how we came up with that number. So there wasn't a full amount that was going to need to be paid in November. All right. You complied with the escrow order. If you didn't understand all that technicality and what I just said, but I understand why that number is different. And I didn't order the whole 55 for November. All right. But in terms, okay, so here's going to be the problem. And I don't know whose problem it's going to be. And this is going to, I don't think that the monies you paid were properly put into a trust account with Ms. Toe.
This right here is the moment everything changes. The judge openly states that the escrow money may not have been properly handled, and that is huge. In legal terms, mishandling escrow funds is one of the most serious issues an attorney can face. And now, the judge is realizing something even worse. Both sides may have been damaged by the same situation. The tenants lost money. The landlord didn't receive rent. And the attorney in the middle may have created a breakdown in the entire system. This is no longer a simple landlord-tenant dispute. It's turning into a professional responsibility issue. And you can hear it, the judge is genuinely trying to figure out how to make this fair, in a situation that may not have a fair solution.
That causes huge problems, which I don't know what I'm going to do with entirely. Because and I'm not sure of the procedure, but typically, and I know it's changed certainly since I've had to do it, where an escrow account or an IOLTA account is mismanaged, there are ways to the state bar of making the person whole. Now, having said that, and that's there used to be, well, I'm sure there's got to be a way of doing that, but I just don't know how that is. Because you guys are never gonna see, well, let's put it this way. You guys are never gonna see that money this term. Have you asked her for the money back?
No, you're not.
I don't think that money's there. I think that that's the money that was used for replacing the sheds and all of that. So,
That's not as.
okay, no, I'm never gonna get
But
my money back.
here's the problem, okay? And just follow this here. Okay, and I think, guys, he's got an Alabama shirt on. Tackle him. No, I'm kidding. Okay. Under the terms of the lease, which is the basis upon which I indicated the monies, you have to pay them, right? That money should have been paid over to plaintiff. Okay?
Money should have been paid every month.
Been paid over to the plaintiff.
Should have been paid
Yes.
over to the plaintiff. Okay? I ruled that.
Yes.
Okay? The problem is that it's hard. So I can't really necessarily give an offset. What really should happen in this case, right? Everything being equal and everything being what it is, and if Miss Tope were participating as one would think a member of the bar should, what should happen is the moment that I ruled that that money should have gone to plaintiff, regardless of whether she spent it on, if she did that improperly out of an IOTA account, she should then pay that money to plaintiff. Right? You guys wouldn't have to pay more. Okay. That's not gonna happen, I don't think. So while let me put it this way. She may have told you those were legitimate expenses. They weren't legitimate expenses.
I hear you.
And so what I'm toiling with, just to be honest with you, is in looking at these numbers, do I hold you accountable for that? Or what do I do with it? Now, I'm toiling with that because also, which is also part of the hearing that I adjourned to the 17th, and why I would be reluctant to let counsel out right at this moment in any event, although it may be moot, is because the bond that I set on the contempt, that would be money that Miss Tope may pay in, was specifically going to be directed toward attorney fees that were being exponentially imploded because of Miss Tope's actions. So I'm going to ask you guys to just give me a few minutes. I'm going to step off because my problem is everybody in this courtroom has been hurt by this person. And I'm trying to find an equitable way to deal with that. Counselor.
I have one suggestion.
Yeah, sure.
And theoretically, how it should work is if the defendants have paid money to their attorneys in IOTA account, equitably, that's still their money, which as you alluded to, would mean that that money is no longer there. They would have a claim against Ms. Tope, most likely through the bar agreements or whatever form they choose. My client does not have that remedy. And so, because we don't have a relationship with Ms. Tope. She's not my client's counsel. She didn't hold, I don't have an IOTA account with her, or neither does my client, for example. So in this scenario, the money that was in there, the defendants, I mean, their contractual obligation is still on them. So if they pay, then their remedy would be, they would actually have a remedy to get it from Ms. Tobe, where my client really theoretically would not. I mean, there might be a creative way to do that, but I'm not aware of this. I've never had a situation like this before, but.
You wouldn't me either. But no, I hear you. And that really had gone through my mind. But and that may be where I land in the next 15 minutes, right? But this is the second case in which Ms. Tope has been involved where people have been damaged. This is really the only one, however, that has damaged both sides, and then to a certain extent, the attorney on the other side, because your fees haven't been paid. And I want to just take a moment to think all that through. If I come up with something creative, I may come up with something creative, or I may not. I mean, I may indeed, and I appreciate what you're saying, counsel. That's where I may land. But I want to just think about that for a moment, because I, quite frankly, have never been through anything like this before either. And, you know, your client's out, your fees, plus he hasn't gotten the rental income. These folks have paid they're out at least what that difference is because they paid it over. So, and now, because of all of that, and I'm not saying it's the entire cause, but because of all of that, he's in foreclosure. You're not in business. It's a beautiful scenario. And it shouldn't be how things should work. And over my 26 years, I'm not sure I've seen one person cause this much damage. Court's going to stand in brief recess.
All right.
This case is a perfect example of how quickly things can spiral when financial handling breaks down in a legal dispute. What started as a disagreement over rent and eviction turned into a much bigger issue involving missing funds, foreclosure, and potential misconduct. The judge is left with an incredibly difficult task, deciding who should bear the financial burden when both sides have clearly suffered losses. And sometimes, that's the reality of the legal system. There isn't always a clean or perfect outcome. One thing is certain. This situation highlights the importance of accountability, transparency, and proper handling of funds in any legal matter. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.